Am I audible?
Yes. Am I audible, ma'am?
Yes.
And I hope I'm visible, because after quite some time I'm using this Zoom app. I'm like little out of touch with this app. So I hope I'm clearly visible and audible to all of you. Yes. Okay, great. So I'll just put this thing up. Okay, so I guess my screen is also quite visible. So I'll just yeah. So now I can see you all. So good afternoon to all of you. My details are there on the screen, and I'll be not kind of teaching you all anything today, but I'll be discussing, or rather giving a bird's eye view of this particular subject, the law of crimes. Now, at the start, let me make it very clear that it can be interactive. And I have been given the understanding that you people have already done certain part in under this particular subject. So today I'm here not to teach you anything, but I'm just here to enlighten you on certain things. If you have already taught, then you are free to discuss that with me. In case of any problem, you can just stop me then and there and ask. But if you have a question, then I would request you to keep it till end, so that, you know, at the end, I'll be taking up all those things. So I hope I'm clear with the things. You can interact, because I can see you in a small inbox there. So can you all speak to me? Can you all discuss? Are you free to unmute yourself or talk to me?
Yes, ma'am.
Yes.
Okay, so I'm audible, right? Because I have a little problem with understanding this particular thing here. Okay, fine. So the first thing is that, you know, I see this subject myself as a student, very much being interested into this subject. I want to learn this subject right from the core. So what is the first thing that I do is a beautifully framed curriculum for all of you. The first thing that comes in my mind when I take this subject of yours is I need to see what the syllabus has in store for you. So if you see the syllabus, there are two main things which you need to be touching upon. I, as a teacher, would not confine and tell you students that read only these two things and leave the rest of the things. But in this curriculum, if you are dealing with these two things, I think you are ready and prepared to deal with other aspects under the criminal law. So the syllabus has two things. Number one, the criminal jurisprudence, and the other one is the Indian Penal Code 1860. Now, I don't want to touch on Indian Penal Code today, because I want to go on my foundation. I want to understand that what is the foundation of the criminal law, which I am so much seeking to understand, right? So what I intend to do in this 1 hour lecture is that I am just going to expose you to certain ideas. As I said, I won't be teaching you anything, because that your teacher is already doing, and I'm sure he's doing in a very beautiful manner, must be teaching you. But as a lawyer, as a student of criminal law, what is it that I should look out for when I'm sitting and learning criminal law for myself, to make a future out of it, you know, to make a career in that? And to put it across, I have practiced on the criminal side for about 4 extensive years, and I have been into Bombay sessions and all other, and handled some very beautiful cases under the able guidance of my senior at that point of time. So I know a little bit about this, which I want to just share with you. That's all. But the first thing, I'm again coming back to my syllabus, is criminal jurisprudence. So my whole criminal jurisprudence, because the moment I master criminal jurisprudence, Indian Penal Code and all the other criminal laws are taken care of by themselves. I just don't have to work much on that. Okay, that is just about knowledge, knowing the substantive law, namely the Indian Penal Code. So what is it that you, as a budding lawyers, what is it that you need to be looking out is to master criminal jurisprudence. I have been given the understanding that you people have already learned criminal jurisprudence. Am I right, sir? Is your teacher around or is anybody
ma'am.
there?
Yes, ma'am.
It's already been taught to.
Studied jurisprudence. No?
Very good.
What all things? Actually, ma'am, I haven't taken this subject. It was some other sir who was taking. So, what all topics you have?
Okay,
Studied?
so I guess the students would know it better, no, what they have
Yes,
learned in
yes,
this
ma'am.
subject. Okay, no problem. So I'll just expose you to certain concepts, certain ideas which you need to know by default. You need to know under the criminal law. See, I cannot master criminal law unless I know criminal jurisprudence. Get that very right on the first day of your studies. Now, what is criminal jurisprudence? That's the first and the very important question. A little caveat at the start, I'm not here to teach you the subject, so I'm just going to run across with you to certain concepts. I think the lecture is getting recorded. You can always seek help and see it again and whatever. But the first thing that we need to understand, and why criminal jurisprudence, we could have done without jurisprudence, right? We could have directly jumped into Indian Penal Code, and that is what I as a student want to learn. But no, without a foundation, a building can never stand tall for years to come. And that is why, for you to understand and master criminal law, you cannot do that unless you have mastered jurisprudence. So the first question that pops up in the mind of a learner is, what is criminal jurisprudence? And I would put it up that it is nothing but a study of fundamental principles of criminal law. Means those concepts, those principles over which the whole of the criminal law is built up. What are those fundamental things? And to your surprise, I hope you know this, but there is no law, no statute, nothing tells us anything about criminal jurisprudence. So it's a kind of an abstract study where we need to know a lot of things before which we can then think of understanding what is Indian Penal Code and various other criminal laws coming down the line in your curriculums. So these are the principles which we need to master. And when I put up the word jurisprudence, it's a Latin term in itself, where juris means law or legal and prudence means knowledge. So as a student of criminal law, you have to first master the basic principles or the basic concepts over which the whole of the Indian criminal justice system is based. So what is that? Because no statute, no books will give you that. No statute or a legislature drafted any law will give you any of these understanding. And you will never find all these things in any statute. And that is why it becomes more difficult and more taxing to understand what these concepts are. And trust me on this, all these things you will understand in a much better way when you start doing experiential learning, when you start going to the courts, when you are interning with somebody and you're seeing all these things happening around you. That is the time when you get the hang of it, you understand it, and that is the time when you start absorbing the criminal laws. So jurisprudence basically means knowledge, legal knowledge of what? Of criminal law. So what are those things with which which are those foundational things over which the whole of your country's criminal justice system is based? And here I am trying to find answers to the questions, as in, what is crime? When a person commits a crime, when do we say that this fellow has committed a crime? So what are those constituent elements of crime? I need to know that first of all. When can a person be exempted from criminal liability? So if I say this blue boy who is sitting right in front, on the chair, if I say that he has committed a crime, how do I say he has committed the crime? In order to impose a liability on this boy as having or accusing him of committing a crime, what are important factors I need to be bringing up so as to implicate him in that particular crime and eventually punish him for that particular crime that he has committed? I want to find out what is the purpose of punishment, what are the kinds of punishment in our country, and so on and so forth. So the whole quest before us is to know what is crime, why crime, what happens if a person commits a crime, and eventually if it is proven that he has committed a crime, then what is the principles of punishment, why punishment given, what kind of punishments are we looking out for, why are the punishments given, and the most important thing in India, which are the kinds of punishments allowed and which are not allowed as compared to the olden years or eras. So this is something at the start you people need to know before you can start enjoying Indian Penal Code. And trust me on this, you will not understand Indian Penal Code in the way it is supposed to be understood unless you are sound with the jurisprudence of criminal law. So my first question always starts with, what is crime? I don't know what is crime because I'm studying Indian Penal Code, I'm studying criminal law. The first hero, the protagonist of this subject is crime. And what is crime? I think, you should be open to answer to the question, because if you have already done it, then you would be, instead of getting bored, you can immediately interact with me. Can somebody tell me what is a crime?
Crime is an intention to hurt someone with.
Okay, great. Crime is an intention. Okay, anybody else? See, let us make it very interactive. Otherwise, you will be bored. I know you had a hectic day, with other lectures, and now again listening to a teacher is very boring. You can interact. Remember, unless you have mastered jurisprudence, you cannot make a good criminal lawyer. Trust me on this. We have tried and tested this. What is crime? Anybody else can just brainstorm, because if you have already done this, you would be able to come up with a better answer. No? Okay, fine. No issues. First of all, crime is nothing but, in law, what do we mean? What do we understand by this concept? It means any act. Please mark the term act. I have not stressed on this word for the simple reason that I'll be interacting with all of you. So what is crime? It is nothing but an act which the law of any country, especially if I'm talking about India, where the law of our country visits with punishment. And in this sense, I can say crime is quite synonymous to the word offense. In India, you will never find any codified law made by the legislature where the word crime is there. In fact, the best thing is, or the joke is, that we are studying Indian Penal Code, everything about crimes, and this word crime, poor thing, has not been defined anywhere. But a synonymous word called offense has been defined very beautifully under section 40, I guess, of Indian Penal Code. Just correct me on the number if I go wrong. So crime and offense, one and the same thing. So when I say that this blue shirt boy sitting over there, he has committed a crime, what exactly do I mean to say? I mean that he has committed an act. Act means an activity, okay? He has done something which is not allowed in the country, and the law of your country is, inflicting punishment for committing that particular act. So whenever this is there, you can say this blue boy has committed a crime. Now, there were many jurists, scholars, the judges in all over the world. They have been brainstorming since decades to come up with the right kind of word, as in what is crime, because the whole heart of criminal law is what is crime. So here Blackstone came up with a definition, and he said crime is nothing but an act which is committed or an act which is omitted in violence of a public law, whether forbidding or commanding it. That means if a person does an act which is forbidden by the law says you should not do a particular act, and you do it, then you will be facing punishment. Or else, if a person does not do something which is supposed to do, then also there is a punishment. So for me to understand the concept of crime, I need to understand that whether crime always means doing something. No, crime involves both the aspects, commission and omission. Like Indian Penal Code, now every one of you know that murder is a crime, right? You can't kill someone. So if I kill someone, what have I done? I have done something which Indian Penal Code has prohibited, and under 300, and under 302 there is a punishment which is prescribed, which goes to the maximum punishment is death penalty. Now, I and all of you all know that we cannot do this act which is prohibited under Indian Penal Code. Now, what happens if I commit this act? I have violated the law, the public law made for the people, and I will be arrested. I will be tried. And if proven guilty, I will be punished. Right? So crime is nothing but doing an act which you are not supposed to do under the law. At the same time, it is not always commission. It also includes omission. Sometimes the law wants you to do something. If you do not do it, then that is wrong. Like for a simple example, I'm supposed, as a salaried person, I'm supposed to pay my taxes, right? This is a duty on me under the law, tax laws, that I need to pay taxes to the government. So here I'm supposed to do something. And what do? I evade my taxes. I don't pay the taxes. So what am I doing? I am not doing something which law wants me to do. So not doing something means omitting to do something which the law mandates me to do. In that case also, what I'm doing is a criminal act. I may be punished under the particular prescribed law. So when somebody says crime, the first thing that must come to your mind is there is a person who is doing something or is omitting to do something which is either the law forbids him from doing or the law is commanding him to do and he is not doing it. So the law commands me not to kill someone. I do it. I have committed a crime. The law commands me to do something and I don't do it. Violate that law by omitting to do that thing. So the law is commanding me and I am not doing it. So what have I done? I have violated certain laws, and for that I will be punished. Now that punishment can be in n number of ways. It has to be in the form of a sanction, right? I hope you are understanding. We are at the same wavelength. Are we? Yes. Okay.
Yes.
Okay. So basically the first and the foremost question comes to us is what is a crime? And this is, I have not defined it, mind it, they have defined it already for us. Then there's a Professor Glanville William, a very renowned name. He says that a crime is a legal wrong that can be followed by criminal proceedings, which may result in punishment. So crime means something which is wrong, which the law has asked you not to do, and you are doing it. So because you are doing a forbidden act, there will be a criminal proceeding. And if it is proven that you have done that forbidden act, then you will have to face the punishment. So he comes up with his definition. What is me and you doing in this? We are just trying to analyze the age-old definitions of crime, for the simple reason that this word crime has not been defined anywhere. So we have no option but to go and check out all the scholarly philosophies given by all these great people. And we are trying to understand them in order to understand our country's law. Bentham, again, another great scholar, he said that if the question relates to a system of law already established, offense means whatever the legislature has prohibited for good or bad reason. So if there is a law which says that don't do this, don't do it, no bhai. Why are you doing it? The law is not meant to just be there on paper. The law prohibits a person from doing something and the person does it. If that thing is good, no issues. If that thing is good, it won't be prohibited also. But if that thing is bad and it has been prohibited by the legislature under a codified law, then what you are doing is something which is a wrong, legally wrong. And you will meet your fate by getting punished. First of all, you will be tried and then you will be punished, right? So crime in a very, very, very simple manner, or in a very small little way, I can give you this. I mean, I can take 10 lectures only on understanding what is crime. That vast is this concept of crime. But as I said, I'm not here to teach you in detail. But yes, my hero always remains crime or offense. You know what? Today, under Indian Penal Code, under Section 40, I want you people to go back and check that, of course, when you're studying your Indian Penal Code. Today, I can give you a very good definition of crime, very simple definition. And what is crime under Section 40? If you extract it and get the simple meaning, crime is nothing but an act or omission which is prohibited by the law for the time being in force. Matlab, an act which the law prohibits you from doing. An act which the law prohibits you from doing, and you do it, then your whatever prohibited act you have done is nothing but a crime. Getting my point? It's a crime. And obviously, if it is a crime, then you will be punished under the respective law. And now you have to think what you have to do. And we lawyers do that. We defend such people who have committed the crimes, and they come to us and we are trying to protect them by, getting them acquitted. So offense basically means this. Now, if we have understood what is crime, then when a person commits a crime, what are the important things which are there? I just have few points over there to just put it across to you. So when I say that this blue shirt boy has committed the crime, what exactly should be there in a jurisprudential manner? This boy must have committed an undesirable act. Undesirable means is equal to prohibited act. There is a law, it has prohibited you from doing a particular thing and you have done that thing. So we can say you have committed a crime. And not just undesirable act. That undesirable act must be not just prohibited by any society, it must be prohibited by the law. And I always give this funny examples to my students, that today we know what all things are crime. What all things are crime. The father of all the criminal law is Indian Penal Code, and that is the most general law made in 1860 by the Britishers. But after that, nothing else came up, or what? No, there are so many other laws which came up. Why? Because human mind goes beyond its limit. Indian Penal Code gave you 511 sections and about 200 odd offenses. But do I mean to say that in our country only these 200 offenses are committed and nothing beyond that? No, human mind goes beyond. So what happened, the wrongdoers or the people with criminal mindset, they knew that there is a law, Indian Penal Code, and it prohibits us from doing a particular thing. And they knew very well that crime means an act which is prohibited and you do it. It is a crime. So they started doing something which was not prohibited. I'll give you certain striking examples. Like, for example, NDPS Act. You all know about what is happening in the country, right? I have a certain amount of cocaine with me, or I'm consuming it or selling it. We all know that there is a drug law. But in 1860, when the Britishers made Indian Penal Code, at that point of time, this NDPS was not there. It came, I think, as late as 1985. There are smuggling acts, there are customs act, there are, foreign exchange regulation laws. There is prostitution law, right? There is a dowry act. There are so many such criminal laws which have came up. Why? Because Indian Penal Code was not sufficient. The kind of offenses it described were very limited, and people were doing all those acts for which there was no law in the country. And what is the definition of crime? An act you do which is prohibited by the law, by the state. Only that act is a crime. So I will be punished for a crime, for an act which is a crime, only if my act is a crime in the eyes of the law. So if I do something for which, against which a law is not made, I'm allowed to do that. Absolutely allowed. Like, some years back, sexual harassment of women and all, till 1997, it was not a crime, sexual harassment of women, not at all a crime. But then came Vishaka's judgment in 1997, where Supreme Court said that, working women need sexual protection. They are sexually molested at the workplace. But the women said, sir, but there is no law. And people take us for granted where we are working and we are molested and there is no law. Where do we lodge a complaint? So men in the working place, thought it their right to harass the women. Why? Because there was no law on sexual harassment. That was the time when Supreme Court, exercised its power and laid down certain guidelines that every working institution, whatever it may be, public or private sector, must follow certain guidelines to protect the women. And you will understand it that till 2013, we did not have the law on sexual harassment of women at workplace. There was only one such guideline which came in 1997. That means sexually harassing a woman till 1997 was not a crime, not at all a crime, until it became a crime, until the Supreme Court entered and made it like, that. But still it was not a crime. It became a crime when in 2013, when Protection of Women Against Sexual Harassment Act came up. The point that I'm trying to make is your act will become a crime only if there is a law which prohibits it. And that law prescribes certain punishment, only then it becomes a crime. Otherwise, do whatever you want to do. Make sure whatever act you are doing, it should not be prohibited by the law. If that happens, then your act is not a crime. You can be, relaxed over there. So for an act to be a crime, it must be not just undesirable act in the eyes of law, but it should be prohibited by the state under certain law. And the state must also prescribe a penalty. So जब हम crime की बात करते हैं ना, तो I am doing a wrong thing prohibited under a law, that law will 200% prescribe a punishment, and that is why it is called as a crime. For every crime you commit, you get punished, which is, penalty. It can be in various ways. You have to be punished, otherwise it won't be a criminal law. Remember that, right? So when a person commits a crime, primarily these three things are there. Now, in the society, a lot of wrong things are happening around us. Okay, now who is responsible for administering justice? Jurist Salmon said that it is the duty of the state to protect the people through its physical force. What the state is doing, the government is doing, the government is trying to protect its people so that crime is not committed in the society. We want a crimeless society, right? And that is why under the criminal jurisprudence, the most important aspect that comes up is administration of justice, which is in the hands of the state. And why do we need administration? Why do we need the government to apply physical force, make laws and protect people from crime? Why do we want that? We could have done very nicely also, no, without all these laws. There are more than 50,000 laws in India. What is the need of having those laws? And if I can put it up, I think no, not more than 25% of the total laws in India are criminal law. That means about 70-75% laws which are made by the legislature, whether the parliament or the state legislature, they are all civil in nature. You have so many civil laws, but quite restricted, limited criminal laws. Why do you think that we need to have laws in our country? So that the government can give justice to people. Suppose I don't like this blue bacha and I give him a tight slap. What will happen? Obviously, he won't like it, no? He will want to take an action against me. So if he's taking an action against me, there should be somebody who must be listening to him. If there is nobody to check my action, then what will happen? Today I'm hitting him, tomorrow I'll hit the other guy. I'll keep on doing this, and what will happen? It will become a big jungle, not worthy of staying. So the only purpose for which we have so many laws is to keep the human beings in their place. And this job is done by your government. And the government is administering justice to people because human beings are violent by nature. Merely by talking and giving public opinion, nobody is going to listen. And especially a person criminal minded like me, I will never stop. I will keep on going beyond my limits and I'll keep on harassing people, and there will be no stability in the society. And that is why we need one person or one force above us, so that they can keep a check and balance on all the human beings under it in that political territory region, so that all the human beings behave themselves and there is a law and order which is there in the society. So basically, administration of justice is done through the force of the state, where the state or the government tries to maintain justice, give justice to every person, maintain stability, let the people be in their own space, place, not go beyond and try to make it a jungle. We are not animals, right? But human beings will not listen to anyone. If I tell you to do something, why should you listen to me? But if the law tells you to do something, you have to listen. Why? Because we all are scared of law. Because if we do not follow the law, there is a sanction, penalty, something or other. So चाहो ना चाहो, हम सबको कानून follow करना पड़ता है. Now, under criminal jurisprudence, why am I talking about administration of justice? Because I'm talking about crime. When I talk about crime, I talk about society. And when I talk about society, who will be taking care of the people in the society? You and I can't take care. No, in fact, you and I are fighting with each other. We have difference of opinion. So there has to be somebody, the physical force of the state, who is trying to administer justice and keep a check and balance on people not committing the crime around. And for that reason, I need you people to now understand, this is all part of criminal jurisprudence. Let me put it across to you, okay? That how would you know that what I have done to you is a crime? अब हमने तो ये समझा, चलो ठीक है, crime ये होता है. Who will look after crime and maintain stability in the society? Fine, government. Suppose I hit this boy, blue boy. I have done a wrong thing, right? Every one of you can say that Sambhitha has done a wrong thing. But whether my wrongful act is a crime or is it a tort, how will we come to know? So a common man doesn't know the difference between the wrongful acts or the acts which are wrong. It is you, the budding lawyers, and we already lawyers, we know that which act is wrong, a tort, and which act is a crime. So don't you think right at the inception of your studies in the first sem of the first year, you need to know the difference between civil wrongs, which you people, I guess, are studying. Do you have law of torts? You have it, right? So you will be studying in great detail what is tort, short and all. But over here under criminal law, you need to know a clear difference between civil wrong and criminal offense. Unless you can demarcate between the two, how are you going to understand that the act committed by me towards that boy sitting in the first bench, or the act that I did of hitting, giving him a slap, was it a civil wrong or was it a crime? How will you understand that? So for that, you'll have to go into the foundation and understand that what is a civil wrong and what is a criminal act or a crime or an offense, whatever and however you put it. Now, one thing, I have just put it up over here, certain demarcations between the two. And I don't know whether you have studied in the law of tort. So if someone from your side can tell me that what difference do you see between a crime and a tort? Yes. Anyone can speak up,
So in difference can be in civil wrong, the person who is, the person can claim damages.
Very good. Very good. He can claim damages. What about criminal act?
For which it can be punished.
Very good. It can be punished. Wonderful. Okay, that is one difference you have given me. There are number of differences because of which, once you identify all these differentiating factor, you'll be able to say that this act is committed by Sambhitha is a crime. It's not a wrong. The act of physically hitting him on his face is a crime. It is not a civil wrong. Right? And hence, this blue boy will not dare to go to the civil court and claim compensation or in your language damages. Why? Because there is no such civil law which gives you damages for this act. However, there is a criminal law which not gives you damages, but the person who has committed this forbidden act of hitting or causing hurt, this person can be punished, if he goes to the right authorities and lodge a complaint against me. That is one such difference. Now, quickly, let us analyze because of the time factor that I have been given. There's a lot to say, but very limited time. So I will just run across with you all. And I'm sure you are quite bright lot. So number one, in civil, when somebody commits a civil wrong or a tort or whatever you call it, you go to the court of law, you are going to the court because that person has violated your legal rights. So you're going to the court to enforce your rights. But in crime, you are going to the court to punish that person for wrong. Punish that person. Indirectly, you're getting your rights are getting settled, but you don't want to claim any remedy, damages, money, shani, nothing. You want to punish that person, and that is the idea behind having the criminal law. The second one is civil wrong means harm to an individual. If I do something, if negligently I do something to another person and whatever loss is caused to him, he can run to the court of law and claim damages for all the loss. So it is me versus that person. Two individuals are there. But in a crime, whenever a crime is committed, it is not a wrongful act against an individual person, but it's against the whole society. And here I give an example. Like, for example, in we all live in a building, and some problem is there. My problem with this blue boy, we both have a problem. Will you all be interested in our problem? No, chodo na yaar, inka ye civil masla hai, paison ka masla hai. Say, for example, I have taken a loan, a friendly loan from him, and now I am not paying him. It's a pure civil case. He can go to the court and file a suit against me and claim that money. आप में से कोई interest लेगा? नहीं, छोड़ो ना, उनका आपस का यार, why we should bother? But imagine, on a fateful day, during the afternoon hours, when all the men are out of the house, there is a robber who comes up inside the house. In my house, he forcibly enters, and on the gunpoint, he robs me, my house, and goes away. The moment this information goes to the whole building will be under a threat. When a crime is committed, it is of course committed against one individual person, but the threatening factor or there is a scare which goes in the society. And that is why when a crime is committed, it is not between two individual persons. The state takes the responsibility and the accused person is punished by the state, by the government. And you must have come across the cases like this, the state of Maharashtra versus XYZ. Who is state of Maharashtra? He is the state is the complainant. So whenever the crime is committed, it is the government who takes up your case and sues the accused person. So that versus ke baad accused person's name comes. But in civil cases, it is me versus somebody else. The names are given. So a crime is always considered as a social wrong, and that is the reason why the prosecutors take up the case of a complainant. So suppose I have tried to kill this blue boy. He goes to the police station and lodge a complaint. Now this is a wrongful thing done between two of us, me versus this boy. The moment he goes to the police station and lodges an FIR against me, the whole state machinery stands up for him. Firstly, the police officer. His job is to start investigating under Criminal Procedure Code. The second thing, after he has done his investigation, you must have heard of filing a charge sheet. He will file the charge sheet in the court. The court will then start conducting the trial. The accused person, I am brought to the court and I am asked, Sambhitha, have you tried to kill him? Have you tried to commit this offense? I say, no, sir, I have not done it. I have falsely been implicated. So I am, who am I? I am the one who has committed the crime. So I am the accused person. And who is that boy? He is the complainant with whom I have committed the crime. For him, the state has provided a prosecutor. So inside the court, there's a prosecutor for him. But for me, I'll have to arrange for a defense lawyer for myself. So the crime is always a societal wrong. And that is why the state takes cognizance of that. The prosecutor fights your case. The complainant doesn't have to do anything except coming to the court during the trial. Thirdly, the plaintiff claims a right and is given such remedy as he wants. Civil mein na, what you want, you are given, but criminal mein aisa nahi hai. Whatever you want, you will be given. So if he lodges a FIR against me and if I have been implicated for this crime, the only thing that I'll get is the punishment or fine, nothing else. So he is going to the police machinery. He is invoking this case so that he can see me get punished for all the wrong thing that I have done to this boy. In civil matters, your whole objective, as somebody rightly said, is to claim damages from the wrongdoer, right? But in criminal, the whole objective of the criminal justice system is to see the accused person being punished. Chhodna nahi hai usko, punishment milke hi mujhe shanti milega. Now, in civil matters, it is individual matter, person versus person. But here, the state takes an action against the accused person, so it is run by the state. And the second last thing is, the individual, suppose I have filed a civil suit against this boy. I have filed it, right? I can always take it back whenever I want. I can withdraw the case. I can put an end to that. But if this boy has lodged an FIR against me for attempt to murder, he's charged me for attempt to murder, start karna uske haath mein hai, khatam karna uske haath mein nahi hai, criminal cases. So if he has lodged an FIR against me and invoked the criminal justice system to get justice, he can never take back the case, whether he wants it or not. Baad mein hum dono ka mandavli bhi ho jayega, chalega. Lekin now that the case has gone to the court, to the agency, to the authorities, to the state, the case cannot be withdrawn. That is the beauty of criminal law. So it is a more serious affair. And lastly, in civil matters, you have to prove what the other person has done sufficiently. But in criminal, the beauty of criminal justice system is that if this boy says that Sambhitha has tried to kill me, then the prosecutor who is fighting the case for him, he will have to prove my guilt beyond reasonable doubts. Matlab 10% prove kar diya, 20%, 50%, sorry boss, 90 and 95%. Beyond reasonable doubt means the judge should come to an understanding that yes, the prosecution, the complainant ka vakil has proved the accused person's guilt beyond any doubts. If you are not able to prove my guilt, then the benefit of doubt will be with me, and I will always request the court to be released or acquitted. You're understanding? So these are very prime distinctions. So whenever a wrongful act is committed by a person, how will you differentiate it? Is it a civil wrong or is it a crime? You will have to measure or gauge it, right? So that is this. Now, this was all the baseline of what is administration of justice and criminal crime and all. Now coming to the crux of the heart of criminal jurisprudence, when I say a person has committed a crime, how will you apply or how will you imply, how will you say that the person is criminally liable? For example, as I said, I tried to kill the boy, the boy. I'm sorry, but I don't know your name, so I'm calling him Blue Boy. So don't mind my words. But if I have tried to kill this blue boy, he has lodged an FIR against me. This you and I all know because we all live in the real world, right? But for the law to hold me criminally liable, what must be there? Any Tom, Dick, and Harry going to the police station and lodging an FIR, is it sufficient to implicate me for this particular crime, which he's alleging that I have committed? I don't think so. Criminal jurisprudence gives you an answer that for me to be implicated in this case, what are those things which are important? And I think you must have done it in your law of torts, or if not in law of torts, I don't know any other subject you have legal language or not. But you know, the whole of our Indian criminal justice system is based on this one maxim. This is a principle. Actus non facit trium nisi mensit rea, means an act done by me will not become a crime unless the act which I have done towards this boy is accompanied by a guilty mind. Have you ever heard of this maxim at any point of time? Or have you heard of this word mens rea ever? हम नॉर्मल डे टू डे में मेंस रिया, गिल्टी माइंड ऐसे शब्दों को सुनते हैं, है ना? या these are common things. You know, anybody lodging a complaint against me, how and when will a criminal liability be imposed on me? That is an important question for a criminal lawyer to know. And that happens when this maxim stands correct. And what does this maxim say? To simplify this, for me to be punished for this crime that I have committed against this blue boy, there must be two prime things which must be there. Number one, there must be a physical element, or we call it in Latin as actus reus. Means I have done an act which is reus, means prohibited. I shouldn't have done this act of trying to kill him, but I have done that prohibited act. So, you know, you can't commit a crime mentally. So I'm sitting over here and gun is getting loaded in my head and I am firing at him. This is not a crime. It's so stupid. But for me to have this mindset that I want to kill this boy because I don't like him, with this mental element, physical element also has to be there. No, I have to actually come down to him, this boy, and with this mental, this guilty mind, this mindset that I have, I don't like him, I want to, you know, harm him, I want to just kill him. I must come up with this mental thing, you know, this thing has to first come into my mind. Mens rea means guilty mind, a mind which is not pure, a mind which is not good, a mind which is full of you know, which thinks about harming someone else. So I have this thing in mind and then I have to physically do something. So first I must have this idea that I should kill him. I must have that intention, in your terms, intention to kill him. And then I have to physically proceed towards him and do something to, you know, what do you say, implement what I'm thinking. So जब भी एक व्यक्ति ये दोनों elements को साथ में लाता है, mental and physical is equal to crime, then you can implicate me for crime. And this is the heart of criminal law. The moment you understand this to the core of it, I think, you know, half of the bit is done. Now, when I say, see, physical element is very simple, but actually not very simple. But let's say physically I hurt him, I get a knife, a huge knife, and I stab this boy. If he dies, I have committed murder. But in our case, he doesn't die, he survives. So what is the charge leveled against me? I have done an act which is prohibited, 307 of IPC. I have attempted to kill him. Why attempt? Because he didn't die. I wanted him to die. He didn't die. But I have still committed a crime under 307 for which I will be punished appropriately under that particular provision. But mere act is not going to make me criminally liable. When I killed him with the knife, there has to be this action, the physical action of mine has to be backed by the mental element. Mental element has to be there. guilty mind. That means, in simple terms, I put it that I should have stabbed this boy either with an intention of killing him, number one, or when I was stabbing him, I should have a knowledge that whatever I am doing is going to take away his life, or else I have negligently done that thing which has led to his loss of life. जब आप कहते हो ना कि मेंस रिया है, किसी व्यक्ति ने ये क्राइम इंटेंशनली किया है, व्हाट यू आर हार्पिंग एट इज द मेंटल एलिमेंट. और पता है कोर्ट के अंदर किसी भी व्यक्ति को किसी भी क्राइम के लिए सजा तब मिलती है जब ये मेंटल एलिमेंट प्रूव होता है. फिजिकल एलिमेंट तो प्रूव हो ही रहा है ना, डेड बॉडी पड़ी हुई है, डेड बॉडी पड़ी है, पोस्टमार्टम रिपोर्ट आ गया कि the death is unnatural, it has been caused because of injuries, the stab wound injuries with the knife, you know, which has gone so much in depth of the body of that person that the person has died. The physical element is all there. I mean, you are able to gauge that, but whether I have harmed him or killed him with that mindset, ये तीन में से क्या तीन, intention, knowledge, negligence, these इन तीनों में से कोई भी एक चीज अगर मेरे इस एक्ट में होगी तो you can say that Sambhitha has committed the crime with mens rea. Guilty mind is there, and unless guilty mind is there, you cannot punish me. Mind it, you cannot punish me. Our system cannot punish a person. इसलिए अक्सर आपने फिल्मों में जो कि गलत होता है, लेकिन अगर आप रियली कोर्ट में जाते हैं, so the whole thing in the court is to prove, the prosecution is trying hard to prove the intention of the accused person to have committed that offense with which that person is being charged. The moment, and what does he do? He just tries to establish mental element, mens rea on the part of the accused person. The prosecutor either tries to prove that he had an intention, with the intention he has done, or he has committed that crime by being negligent, or he had the knowledge. And trust me on this, take up Indian Penal Code today evening when you go back home, take up any offense randomly, and you will find that one out of these words, 3 words will be there. Whoever commits the act with an intention or knowledge or this or that, every crime in Indian Penal Code has these 2 words, preferably intention and knowledge. Why? Because if a thing is happening by accident, it is not a crime. So for example, if this boy is falling out of a building, I just try to help him up, but मेरे हाथ से छूट जाता है, वो गिर जाता है, मर जाता है. I have not done it. Did I do anything intentionally? Did I do with the knowledge to take away his life? Or was I negligent? On the contrary, I was so careful. I was trying to protect this poor boy, but coincidentally, he died and all the blame came upon me. So now the whole quest is that the courts, the judicial system has to prove that whether Sambhitha had the mental element. If they can prove that I had a guilty mind in his death, being caused, then I will be punished for this act of murder, which you put it up. But if they cannot prove it, if this mental element, तीनों में से एक भी चीज prove नहीं हुआ, I have every chances of getting an acquittal. And we as criminal lawyers just harp on these 3 things. So this is the heart of every criminal crime. I hope I am understandable. Because I have only 5 minutes to this remaining. Now here I had, actually given you, but if your teacher is there, madam, are you there?
Yes, ma'am.
How much time do I get? But because, I could not, I thought I cannot do justice. And I told madam that I'll at least need 2 lectures without knowing that what is the nature of audience that I have. But then I have not even reached in the middle. So should I just wind it up like that, brushing away the things and just wind up, or else what? Just
You
let me know.
You can continue if it is possible, or
I mean, I would want to ask your students, because poor thing, they should not get bored, no? What do you say,
If he
students?
has a time limit, we can have few more lectures.
yeah, we can have few more lectures, or if you can continue, we can continue.
I can continue. I have no issues, but provided the students are comfortable with it. I mean, I
Are you
don't want to
comfortable?
burden.
Yes, they are saying they are comfortable.
Okay, I'll just try to brush off. I'll just try to finish it off. Acha, I want to know from you students that has all these things been taken up with you? I mean,
Yes.
taken up, no?
Yes.
Okay, fine. So I will not waste much time on things which have been taken up, but yes, I would want to show certain things. I think they may not have been taken up with you. So I'm just going to brush up. At any point of time, you can put up your questions, or else tomorrow I am also meeting you up again. I don't have much to teach you in Indian Penal Code, but this is very important. The moment you master this, nobody much needs to do a lot of things over there. Now here in intention, I want you people to tell me what is an intention. Just give me crisp answer to that. When do you say the person's act is an intentional act? And I'll tell you something, even a practicing lawyer, you catch up a practicing lawyer and ask him, do you know the meaning of this? Trust me on this, nobody will give you an appropriate answer. What do you mean by the term intention? And how do you differentiate this word intention with the motive? There is such a thin line between the two. And in the court of law, it is the intention that matters and not motive. But in some places, motive matters. Now, if you can play with all these things, I think, you have mastered criminal law. But most of us don't understand the meaning of all these things to the core. And that is why we are a failure when we become a lawyer, because the battle is all about proving the intention of the accused person and nothing else. So if this blue boy wants me to be punished, he needs to prove intention. Mens rea in the court of law, and the most important aspect of mens rea is intention. So if you ask me what is intention, I will just put it up. I mean, you can read it so that you can save out some time on this. When I say intention, it means what, It means the second one. Salmond has very beautifully put it up. Intention means foreknowledge of the act coupled with the desire. I desire to kill the blue boy. Is desire enough? No, I have to do physically some act also. So my desire to do that particular desire to reach a consequence, which is shown here, plus foresight of consequence, that is equal to intention. So I want to kill him. So what do? I know he's sitting in DM Harish School of Law and I'm sitting over here in Nari Gursani Law College. I take my gun. I go to the window and I fire. Will the goalie go like that and come and hit him? No, na. Obviously, he will never die. For me to kill him, I'll have to come to his place or call him to my place. He has to be in physical proximity. Then probably I'll take a gun or a weapon and then I'll try to inflict harm or injury upon him to reach the desire that I want. And my desire is to kill him. That is the desire. Agar her intention sirf desire hoti na, तो हम सब खून कर रहे होते या हम सब क्राइम कर रहे होते. But an intention under criminal law will be so when the person not just has a desire to achieve something, but he also has the foresight of the consequence. Mere desire is not enough, so I will have to do something physically also. So by physically going to him, taking my knife out and stabbing him, the way I'm stabbing him, what I want to kill him. That is the consequence I want to reach. I have the desire to reach that consequence. And I have to do physically that act. While I'm doing the physically that act, there is a foresight that whatever I'm doing, it is going to lead to the desire. You can say this is intentional act on my part. So somebody says intention means desire. Wrong. Intention means not the desire, but with that desire, there is a foreknowledge that whatever you are doing with that person will lead you to fulfill your desire. That is intention. If you were to ask me, I would say it took me years to master this, and it took me back to the memory lane to understand that what is intention, yaar. And this is the most difficult thing in criminal law, to understand and demarcate mens rea. The moment you crack it, you have won half the battle, because in the court intention ही prove की जा रही होती है, और बहुत difficult है कैसे intention आप prove करोगे court के अंदर. So when I say intention, I mean there is a foreknowledge of an act coupled with the desire. So doing a thing, a consequence, and also you have a foresight that you are leading to that particular consequence. ये दोनों चीजें साथ में होती हैं तो आप कहते हो the person is doing that act with an intention. Now this is something really practical and difficult. I don't know, but I taught this to my students, so I cannot gauge that you have less intelligence to understand this. But yes, I am exposing you and elevating you to a final year subjects. Like I happen to teach Criminal Procedure Code, I happen to teach Indian Evidence Act, so I can connect Indian Penal Code with all those things. So law is all connected, you know. You don't study a particular law in isolation, you have to connect to other laws as well. Now कोर्ट के अंदर आपने अक्सर देखा होगा, so the whole idea of the prosecution is to prove that the accused person has committed this crime and there was mens rea, actus reus भी किया है इसने, physically harm किया सामने वाले को, and there was mental element also over there. So how does this fellow prove it in the court of law? ये देखिए, मैं आपके सहूलियत के लिए चारों पॉइंटर्स डाल देती हूँ, आप देखिए how much can you absorb. Yes, anything you want to say?
Nothing, ma'am.
See here, I have taken you to directly to Indian Evidence Act because how to prove a particular thing is always going to call for the help from Indian Evidence Act. Intention of a person can be gathered from what he says following the res gestae rule as given in section 6 of Indian Evidence Act. I'll give you a very simple example, not to go on to a very heavy thing. Now, you know, I wanted to kill this blue boy. So what I did, I said, I called him to a particular place and this boy came over there. When he came over there, I already had an intention of killing him. I had all the preparations done with me. So when he came to me, the place, the time, the area where I called was quite isolated, but not so isolated. He came over there. We had a discussion or a scuffle or a fight or something, and I, out of, you know, I already had that revenge against him or animosity towards him. I just took a knife from my bag and I stabbed him multiple times. Now when I'm doing this particular thing, stabbing him multiple times to implicate me into for this particular crime or to impose a criminal liability, physical element, mental element, physical element hai, I stab him multiple times and he falls down and dies on the spot. Right? I am arrested. Now, the burden of the prosecution is to prove that Sambhitha has not just done this actus reus, but she had every intention. So he will try to club both the elements together in order to see that I am punished severely for this murder. But in the court of law, whatever the complainant, a lawyer, prosecutor is trying to put up in the court, he needs to substantiate it with the help of evidences. Does he have the evidence? Now here his job is to prove that Sambhitha had an intention of killing this boy. How will he prove the intention thing, Baba? Very difficult. And the best way of proving intention is eyewitnesses. So when I killed this boy next to him in the black shirt, he was present in the vicinity and he saw this thing happening. The girl, the people you are sitting behind, you know, all of you, you all saw. So what happens? I kill him and I run away. At some point of time, the body will be recovered by the police. Somebody will go and lodge a complaint. Sahab, udhar ek dead body padi hai. The police will come. And trust me, everything I say is practical, nothing bookish. I don't teach bookish things. The police wala will come over there, sees the dead body, sent to postmortem, the cause of death to be found. Now the question is, who killed him? And immediately he will start going into the vicinity. Who killed this man? Who killed this man? And suddenly all of you will be traced who live in the vicinity. One person the police wala should get. The police wala gets this black boy. Did you see? And he's very scared, you know. Yes, sir, I saw there was this fat lady and then she did this and all. What is he doing? He is narrating the whole incident. Through his incident, the police wala is trying to understand that whatever Sambhitha did to this diseased person was an intentional act. You know, there with the story statement given by this black boy, it is depicting that not just physical element, but mental element is also getting established over there. He is a star witness, an eyewitness. Then the police wala goes around. Anybody else was there? Haan saab, ye bhi tha, wo bhi tha, wo bhi tha. The police reaches out to all of you eyewitnesses and each one narrates what they have seen. So what is happening over here? The law totally, criminal law totally functions on eyewitnesses. They are the heart and soul of any criminal proceeding. So the eyewitnesses are going to establish that the act was done. The crime which was done was an intentional act. That means there was a desire. You could all see that I was full of rage. I took out the knife and I stabbed him not once, multiple times. So you all are narrating that we not just saw that she had a desire, but we saw that her hatred, what she had, with that hatred, she did whatever she could do to reach to that consequence that she wanted. Sahab, humne dekha. And that is why, remember, in criminal matters, in all serious criminal matters, it's the eyewitnesses who are the ones who will establish the crime in the court of law. And the moment the witnesses establish the intention factor, done. The criminal liability on my part established, and I'll be punished for that act, right? There are a lot of other things, but I think unless some other occasion I'll be putting up, but I thought maybe you can, So all the evidences which can show that the person wanted to do that particular act. Now, sometimes you students, I mean, my students, obviously, they come up with thousands of questions, they don't sit and listen very quietly. They are always bombarding me with questions. We are more like discussing. But of course, this is this thing. So now there's a difference between intention and motive. One very simple thing that I want to put up over here, and not going into detail of this, is that, intention and motive, I would say these are two brothers. The big brother is intention and the smaller brother is motive. I'll put up some things over here, self-explanatory. Intention is different from motive. Motive is the reason, and intention is the desire for the consequence. I desire to kill this boy, and with this desire I did an act with which there was a foreknowledge that whatever I am doing will lead to my desire being fulfilled. Intention. But in motive it is not so. There's a vast difference between the two. कहने के लिए ना आप interchangeably इन दोनों शब्दों को use करते हो. अरे he had a motive, don't use it. Motive नहीं चलता कोर्ट में. और अगर मेरे को बहुत सिंपल तरह से डालना हो ना, आप लोगों की अंडरस्टैंडिंग के लिए बहुत सिंपल वे में डालना हो, तो मैं ये कहूंगी कि कोर्ट में ना जब आई विटनेस होता है और वो कहता है कि हमने ये औरत को, ऐसी डिस्क्रिप्शन की औरत को, इस आदमी को मारते हुए देखा, when eyewitnesses establish the fact showing and proving that I had an intention of doing, at that point of time जब eyewitnesses वो पूरा इवेंट बताते हैं ना, तो वहां से intention establish हो जाती है. But on the contrary, I'm sure you all know that 90% murder matters के अंदर आई विटनेसेस नहीं ही होते हैं. मतलब मुझे बताओ, कोई आदमी खून करने जाएगा, बोलेगा आओ आओ दुनिया वालों देखो, नहीं ना, मैं प्लान करूंगी, प्लॉट करूंगी, आइसोलेशन में करूंगी, ताकि कोई भी ट्रेस एलिमेंट बचे ही ना. So I'm planning the murder of this boy, and I plan it in such a way, it takes me days together to plan and plot and all, so that not even a single eyewitness. So I call him in an isolated place and I kill him in such a way that not even a single bird has watched me doing that. Now tell me, the dead body is recovered, the matter is taken up, the police wala is investigating, who is the culprit? Nobody knows. This is what happens. If you see Crime Patrol, to a large extent, it's the correct depiction of the real things. Please don't watch CID and other nonsense things, especially the courtroom drama. They are all nonsense, false things which are shown in the cinema just to glamorize things. But in the real world, when eyewitnesses are there and they narrate the event of the crime, then through their narration or statement or testimony, intention of the accused is getting proved. But when you don't have eyewitnesses, then what do? Nobody has seen it, but murder has taken place. The post-mortem report says that the death is an unnatural death. Death to hui hai, khoon bhi hai ye, kisne kiya? Then comes because intention cannot be proved because nobody has seen it. Then comes the question of who has the reason, who has the motive. और आपने अक्सर नोट किया होगा, in all the genuine series that you watch, the police goes around and tries to ask people, किसने किया होगा ये, किसके पास कारण होगा, लास्ट किसके साथ पाया गया था ये ब्लू बच्चा, किसके साथ इसका कोई झगड़ा था, मनमुटाव था. अक्सर आप देखते हैं and वो रियल होता है. The police is trying to find out who would have the reason to kill that blue boy. So all the people, his friends, everyone says, no, he was such a nice boy, this. But suddenly one person out of the blue tells the police wala, he was a very nice guy, but पिछले कुछ दिनों से ना काफी परेशान था, because एक औरत है ना, एक ऐसी मोटी सी औरत, उसने नाम भी बताया था डबराल करके, that lady was, somewhere he was very troubled with that lady. बस कहते हैं ना, अंधेरे में तीर चलाना, मिल गया, अंधेरे में हाथ में बटेर लग गई पुलिस के. Now the police will start investigating that. First of all, merely on the basis of suspicion, the police officer can arrest me under section 41 of Criminal Procedure Code. पहले तो मुझे पकड़ेंगे, they will question me. From me, a lot of things will come out, and all the circumstantial evidences will be gathered. तो जहां इंटेंशन सिद्ध नहीं होती, वहां पे मोटिव पे हाफ किया जाता है, that who has the reason to commit the crime. And there are thousands of cases which you will study eventually in your this thing when your teachers are teaching, that on the basis of circumstantial evidences, the courts have given death penalty as well. Getting my point? So here I have put up what is motive. Motive is nothing but the idea, belief, or emotion that impels a person to act in accordance with that state of mind. A very simple illustration. You intend to join DM Harish Law College. That is your intention. You took admission. What was the intention? Admission lene ka, so that you can get admitted. Why did you give that CET exam? The intention was to get admitted to DM Harish. Now, taking that intention further, why do you intend to study law? Because you want to get a degree so that you can work in corporate sector, this, that sector. So intention or motive are intertwined with each other, right? But in criminal law, intention stands upfront. It is the intention which the court will see of the accused person. If intention is not to be found, then the court will try to find out who had the motive, the reason to commit this crime, and all the evidences which tries to show the motive factor may then be probably proved in the court of law. Right? Now, intention and knowledge is there. Now, I will just put it up as in what is knowledge and what is the difference between intention and knowledge. Can somebody tell me the difference between the two? I commit an act with an intention, a crime with an intention to harm someone. On the contrary, I commit an act not with an intention, but there's a knowledge that I have. Is the two words, are these two words different?
Yes, ma'am.
Yes. How are they different?
So as it is mentioned, intention is the desire, and in knowledge there is no desire.
In knowledge, there is absence of desire. But I know that I'm doing something to this person, but I don't want to do that thing. For example, I'm walking on the road and this black bacha is coming from in front and there happens to be a dash. I'm sorry, but both of you are only seen by me, so I can't help it. And this is how I teach, I connect my students to the whole of the scenario, so they feel a part of my discussion all the time. So एक झटका लग जाता है ना, कंधे से लग जाती है, and you know how women, मेरे को धक्का मार दिया, what is this? And this man says, hello, sorry, I said, no, by mistake ho gaya. Na, what by mistake? I enter into a verbal fight with him, and and he also is very hot tempered. He starts fighting with me, and so on and so forth. And what happens? And suppose I happen to be, during the whole of the scenario, I hit him. Out of that gussa, I hit him. He also hits me. I bounce back. I hit him more. To such an extent that at one point of time, I get so mad with rage that I take a stone from the ground and hit him on his head, and he dies on the spot. Now, when the real cases come before us, this is what we need to find out. Was my act an intentional act, or was my act without intention? Now, I did not know this boy. I had no reason to kill him. Why will I desire to kill him? But in the whole of this fight, wrong or right fight, what has happened is I picked up the stone because he's a big boy and he was overpowering me. So in order to harm him or stop him from doing that, I picked up a stone just like that and hit him on the head, because I know very well that head is a soft spot. If I hit him on the arm, probably he won't stop hitting me. So I take it and hit it on his head. Now, do I have a desire to kill him? Obviously not. Maybe the desire is self-preservation. 10 minutes more. Maybe my desire is just to preserve myself because he is trying to hit me. Now here what is happening is there is absence of desire to kill him. But what I am doing, I am not a small child, na, that I don't know the repercussion of my act. A prudent man will know na, that if I hit a big stone and hit on someone's head, is every likelihood that he will die. So here the law says that no doubt Sambhitha didn't have the desire, but she knew at the back of her mind that whatever she is doing will cause harm to the person. So जब भी कोई व्यक्ति knowledge के साथ, knowing what he is doing, knowing the repercussion, maybe not wanting it, but knowing the repercussion of his act, then the knowledge part is also taken as mens rea. I'm not a baby to not understand. I did that and I hit him on the soft spot of the head with the, not with the desire, but to stop him. So the law sees knowledge, doing an act, committing a crime with the knowledge as also a part of mens rea. Very important over here. And the third thing that is there is negligence. Negligence is what you are supposed to take care of certain things and you don't take care and it leads to harm to someone else. I'm negligent. Like take up the Salman Khan's case, drunk and drive, and you are totally drunk and you're driving and the people walking on the pedestrian, I just take my car. Do I have the intention? No. Do I have the knowledge? Maybe not, because I am so much under the bad influence of alcohol that I'm not able to understand the repercussion of my act. So maybe knowledge also may not be there, but the third element is there. Negligence. Negligence means what? Absence of duty. You owe a duty, you do not fulfill your duty and you cause harm to someone. Not that you wanted to cause harm, but you were negligent, careless, reckless. You did not take care and hence the harm is caused to another person. In criminal law, negligence is also one of the important elements under mens rea. So हर बार गुनाह जब कमिट होते हैं ना, क्राइम हमेशा इंटेंशनल नहीं होते हैं, कई बार विद नॉलेज होते हैं. एंड यू मस्ट रीड सेक्शन 300 and all the other offenses, serious offenses, where it is said whoever does so and so thing with an intention or knowledge or this, ये intention और knowledge word interchangeably आपको हर crime में मिलेंगे. That means what? For any person to be held criminally liable for a crime, for that particular crime as such, there has to be the presence of mens rea to the extent of not negligence all the time, but intention और knowledge. दोनों में से एक चीज अक्सर होती है, तब जाकर आप सामने वाले को criminally liable ठहरा पाते हो. अब सैलमन ने यहाँ पे नेग्लिजेंस पे थियोरी दी जो आप टॉर्ट्स में पढ़ेंगे. देयर इज सब्जेक्टिव थियोरी, ऑब्जेक्टिव थियोरी. सैलमन का मानना है कि लोग जब क्राइम कमिट करते हैं नेग्लिजेंस की वजह से, तो नेग्लिजेंस इज अ मेंटल एलिमेंट. यू आर रेकलेस बाय नेचर, मेंटली यू आर रेकलेस. दूसरा होता है फिजिकली यू आर रेकलेस. तो बट फॉर अ पर्सन टू बी इम्प्लीकेटेड एंड हेल्ड लायबल फॉर अ क्राइम अंडर नेग्लिजेंस, both these elements must be there, the physical as well as mental. So subjective and objective, both these theory must stand true. So 304A na, is that A or B? A, I guess. No, 304, I guess. Causing death by rash and negligent act, with which your Salman Khan was charged. So he committed an act not intentionally. He didn't kill so many people, nor did he do it knowingly, but he was negligent. You cannot drink and drive. There are norms. There is Motor Vehicles Act of 88. There are so many traffic laws which you need to follow when you're driving. You did not follow what, there is negligence is omission to take care, I would say. And hence that fellow is punished. So negligence also is a part of mens rea. So the sooner or better you understand that these three strong elements are there, one or more has to be there for a person to be held criminally liable, better for us to understand criminal law. Okay, so now crime is committed. I will quickly just give me 10 more minutes. I'll wind this thing up. Now I have committed the crime. When a person commits a crime, he just dhram se doesn't commit a crime. Under criminal jurisprudence, there are stages of committing crime. 1, 2, 3, 4. The first stage is intention. It should come in my mind that I need to kill this blue boy. Mind is not enough. Then I prepare, because he's a big boy, I cannot overpower. So I try to get weapons. I'm preparing, either I'm getting poison or weapon. So whenever a person commits a crime, understand there has to be one or more stages of this. One is thinking, second is preparing, third is doing. I meet him, call him, I meet at a particular place, I take out the knife and stab him. What have I done? By stabbing him, I have attempted to commit the crime. What is my desire? The desire is to kill him. He should die. I have attempted to kill him. I give him a stab wound and this boy falls down. If he dies, I have committed the crime, the desire that I wanted. So the fourth one always is the commission. So this is simple. Anybody can understand. Now, what is difficult to understand is at which stage can you hold the person liable? So I'm sitting over here and I'm full of hatred and vengeance for this blue boy. I have an intention of killing. The boy comes to know, or that black boy comes to know. He goes to the police station. Sir, that madam, no, she is intending to kill my friend here. Will the police wala come and arrest me? Logically, will the police wala come and arrest me? No, never. जब आप कोई बंदा क्राइम करता है तो कौन से स्टेज पे वो आएगा कि उसे पनिश कर सकते हैं? इंटेंशन का स्टेज फर्स्ट स्टेज होता है. इफ यू आर ओनली इन द फर्स्ट स्टेज, नो क्रिमिनल लायबिलिटी कैन बी इम्पोज्ड अपॉन यू because it's a mental thing. Physical has to be done yet. The second one is I start preparing. So I will feed him something and I'll put poison in that. तो मैं मस्त खाने की कोई चीज लाती हूँ, उसके अंदर पॉइजन डाल देती हूँ और ब्लू बच्चे को बोलती हूँ ये ले, मैं तेरे लिए लेकर आई हूँ. By procuring the poison, putting in the food and giving it and placing it, doing all these things is preparing. ये second stage है, मैं prepare कर रही हूँ crime commit करने के लिए पूरी तरह से. अब अगर ये ब्लैक बच्चे को पता पड़ गया कि संभीता खाने में जहर डालने के लिए जहर लेकर आ रही है, वो पुलिस के पास भाग के जाता है, मैं साहब उसने जहर लेकर आया है. Can the police वाला arrest me? It is too early a stage. जब पुलिस वाला मेरे पास आता है, गुडविल में भी आ जाता है, मैडम मैंने सुना है आप खून करना चाहते हो, आप पॉइजन लाए हो. क्या साहब, आप भी, ये पॉइजन मेरे घर में चूहे बहुत हो गए हैं तो आई हैव जस्ट ब्रॉट इट टू किल देम. वेरी डेंजरस. प्रिपरेशन स्टेज पर आप मुझे नहीं अरेस्ट कर सकते. मुझे अरेस्ट करने के लिए ना किसी भी क्राइम के लिए अटेम्प्ट स्टेज तक आना पड़ेगा. मतलब वो खाना मैं ये ब्लू बच्चे को दे देती हूँ, बेटा ले खाना खा, मैं तेरे लिए लाई हूँ. The moment I give it to him, I have attempted. He takes the food, puts in his mouth, dies. Whatever I desired, committed. The fourth stage, committed. So whenever a person commits whichever crime, you as lawyers need to know that at which stage can you punish the person. I'll give you certain exceptions. There are certain offenses in Indian Penal Code which are punishable even at the preparation stage. Preparation to commit dacoity, 399-402 of Indian Penal Code. You know what? The dacoits, when they are planning to commit dacoity, they don't have to commit dacoity. Commission तक आने की जरूरत नहीं है. Planning, preparation कर रहे हैं. अच्छा अच्छा डकैती के लिए 5 लोग होने चाहिए कम से कम. मैं, ब्लू बॉय, ये और 2 और आप लोग, हम 5. तो मैं सरगना हूं, मैं बोलती हूँ ब्लू बच्चे तू हथियार ले आया. हाँ मैडम मैं ले आया. ब्लैक बच्चे तू बाकी सब ले आया. हाँ एक काम करना, वो जो पीछे दाढ़ी वाला बच्चा है ना, तू बाहर रहेगा, तू उधर देखना. एंड while we are committing the dacoity, you will be out there. So there are 5 of us at least planning to commit a dacoity. Now the law says that dacoity is a serious offense which needs to be stopped right at the preparation stage. तो जब हम planning plotting कर रहे हैं ना, उसी वक्त भी अगर पुलिस को पता पड़ गया ना, किसी ने information दे दी ना, तो they can arrest us. Why? Because Indian Penal Code allows. So you as lawyers need to know that which crime is punishable at which stage. Most of the crimes are punishable at the 3rd stage, but there are some exceptional crime. Like, you're planning to wage war against the state. You're trying to topple the government. Section 121, 22, 23 of Indian Penal Code, waging war against the, वो preparation stage पर ही punishable है. आपको पकड़ लिया ना, so it's a serious offense. I think life imprisonment या किसी के लिए तो death penalty भी है. So ये गवर्नमेंट डिसाइड करती है, लॉ डिसाइड करते हैं कि कौन सा क्राइम कौन से स्टेज में पनिशेबल है. सो every crime doesn't have to reach the 4th stage. Even at the 2nd stage, the person can be punished. It depends what kind of crime he is planning to do. So you as lawyers need to go in detail of all these things. And the last thing that I have over here is what is punishment and why punishment. So anyone commits a crime, he needs to be taught a lesson. But the objective of giving the punishment to a person who has committed a crime is not to torture him. Now, these are the reasons. The objective is to teach him a lesson and set an example onto others in the society that tomorrow if you plan to do some such thing, you will also face the same consequence. तो लोग डरते हैं ना, यार मैं नहीं करता, मेरे साथ भी ये हो जाएगा. तो पनिशमेंट का मकसद होता है सामने वाले को टू टीच अ लेसन. एंड विद दिस ऑब्जेक्टिव, यू नो व्हाट हैज हैपेंड इन इंडिया, that since time immemorial, you people would be knowing, you must have seen old Hollywood, Bollywood movies जहाँ पे बड़े अनोखे तरह होते थे पनिशमेंट करने के. उबलते तेल में डाल दो, जमीन में जिंदा डाल दो, दीवारों में चुनवा दो, भूखे शेर के सामने. These were all kinds of punishment. हाथ काट दो, गर्दन काट दो, हाथी के पांव के नीचे. Over the period of time when the society developed, you know, especially in India, especially when the Britishers made Indian Penal Code, they did not like this barbarous forms of punishment. So they said, see, if a person has committed a crime, eventually he is a human being. If you want to punish him, then punish him properly. There should be only certain kinds of punishment which should be awarded and nothing more and nothing less. So 53 to 74 of Indian Penal Code lays down all the kinds of punishment that are there allowed in India. And if I have to name them, India में सिर्फ 5 तरह की सजाएं होती है. Number 1, the most grave one, death penalty. ABCDE में मैंने दिया है किन किन ऑफेंसेस के लिए डेथ पेनल्टी प्रेस्क्राइब्ड है. आई थिंक और भी होंगे पूरे इंडियन पिनल कोड में. आई थिंक नॉट मोर देन 7 to 8 ऑफेंसेस ऐसे हैं जिनके लिए डेथ पेनल्टी है, बाकी सबके लिए नहीं है. दूसरा है imprisonment for life. तीसरा है imprisonment that can be for n number of years, 3 years, 5 years, 7 years, whatever. Now imprisonment under the criminal justice system are of various kinds. Simple imprisonment मतलब अगर crime prove हो गया, sentence हो गई, punishment हो गई, punishment, the person will be sent to the jail and he'll have to undergo certain years or months inside the jail. That is punishment enough for him. The second thing is you be inside and do with hard labor, rigorous imprisonment. And whether the punishment will be simple or rigorous, Indian Penal Code tells you over there only. And most of the punishments are not rigorous in nature. They are simple. क्योंकि जेल के अंदर कुछ साल रहना अपने आप में ही बहुत डेंजरस चीज है एक आदमी के लिए. लेकिन if your offense is so grave and heinous that if the law wants that this person must not just stay in the jail for 10 years, but he must undergo rigorous punishment, means you will have to do hard labor inside the jail to teach you a lesson that Baba, crime doesn't pay. Solitary confinement, ये इंडिया में एक्सरसाइज नहीं होती, but you will study in 73, 74 of Indian Penal Code. The fourth kind of punishment is like, you know, the white collar crimes and all money related crimes. For feature आपकी property जब्त कर ली जाती है. That is also a kind of punishment. And the last and the सबसे छोटू, fine. छोटे छोटे गुनाह होते हैं ना, उनके लिए फाइन. आपने जो है रेलवे का प्रॉपर्टी को डिस्ट्रॉय कर दिया, फाइन दे दो, 500 रुपए फाइन, 200 रुपए फाइन. ऐसे भी छोटे छोटे चिंटू गुनाह हैं जिनके लिए फाइन प्रेस्क्राइब किया गया है. तो सबसे सिवियर है डेथ पेनाल्टी और सबसे छोटी है फाइन. और याद रखना, इंडिया में इन 5 के सिवाय और कोई तरह से आपको किसी भी क्राइम के लिए कोई और सजा नहीं हो सकती. And this you know now very well, and you will know it still better when you go. And then, you know, you can think that if we have death penalty in India, there's a lot of debate going on whether it is justified or not and all. That is for you to think. And the last thing in line is, if we have punishment, then there are certain theories of punishments which are associated with it. Now, why do we have punishment? You know, बहुत सारे लोग सदियों से आए गए, कई लोगों ने बोला, जो नरम दिल के थे, बोले यार डेथ पेनल्टी इज टू बैड अ पनिशमेंट, यार ऐसा नहीं होना चाहिए. कुछ लोगों की कुछ सोच, ऐसे बड़े स्कॉलर्स आए और बहुत सारी पनिशमेंट की थियरीज आई. अब ये बेसिकली थियरी 5 ही हैं. पहला है डेटरेंट थियरी, शायद आपने पढ़ा होगा. मतलब पनिशमेंट इज गिवन टू अ पर्सन टू स्केयर हिम, to deter not just him but other people in the society that you do this and you will meet the same fate. The purpose of giving punishment is to scare the people, to make the people understand that they are not supposed to do certain things and be within their limit. Don't try to exceed your limit. Now this is how you will maintain law and order in the society, right? So the objective of giving punishment is to deter people. So जो deterrent theory के propounders थे, उनका मानना था कि गुनाहों के लिए सजा इतनी सख्त होनी चाहिए कि वो सजा को देख के लोग deter करें, डरें. दूसरी theory थी retributive. Now there were some other scholars who felt that the objective of giving punishment should be to not just teach the wrongdoer, offender a lesson, but to tit for tat, an eye for an eye, a tooth for a tooth, you know, a life for a life. तूने मुझे थप्पड़ मारा, इसको थप्पड़ मारो. So the objective of punishment, this theory propounders said that when a person commits a crime, he should meet the same fate. So if you have killed someone, पुराने जमाने में क्या होता था, तुम्हारे परिवार को मार दिया जाता था, तुमने मारा ना किसी को, तो न्याय ये कहता है कि तुम्हारा भी कोई और किसी को मरना चाहिए. Retributive theory was never good for the society. The third theory was preventive theory. Means if a person is committing a crime, the best thing is remove him from the society. Prevent करो. जैसे घर में कॉकरोच आते हैं तो we put all those medicines ki they are prevented from coming because we don't like them. So if a person is committing a crime, the best thing is to prevent him. How will you prevent? By putting him into incarceration. जेल में डाल दो. ज्यादा severe crime किया तो death penalty दे दो. Permanently prevented from committing any further crime. So this theory said that the person who are committing the crime must be prevented from being in the society so that people can live peacefully. Reformative लोगों का मानना था यार ठीक है ना, crime किया तो क्या हुआ, हो जाता है कभी कभी crime ना, तो ऐसे थोड़ी है, you don't be so harsh. Reform करो, criminals को reform करो. You must have heard of Kiran Bedi. She brought major transformations in Tihar jail in Delhi, where now if you see the situation of the jails, they are much better. They have spiritual classes and whatnot, because they believe, the people believing this theory believe that no one is a born criminal. If somebody has committed a crime, no doubt teach him a lesson by putting him into incarceration, but he is not inherently a bad person. Try to bring reformation from within, so that when he undergoes the punishment and comes out, he should be a changed person and he should not want to. So the whole objective of giving punishment should be to reform the criminal. They believed in that. Expiation theory means to feel, or rather to repent for what you have done. This theory we are not following in India. The last one is compensation. कईयों का ये मानना है, लोग अक्सर क्राइम करते हैं पैसों के लिए, लेकिन कुछ लोगों ने कहा सेक्सुअल क्राइम को क्या कहोगे, वो पैसों के लिए तो नहीं होता ना, वो तो आपके अननेसेसरी लस्ट को फुलफिल करने के लिए है. सो एवरीबडी हैड डिफरेंट थियरीज in connection to crime. The question that comes up before you all is, in India, when we have so many types of crime, section 53 to 74 dealing with crime, then what is it? Which theory is followed in India when we are giving punishment? Can anybody tell me which of the theory given over here is followed in Indian criminal justice system? Any guesses? Yes.
Preventive.
Preventive
And reformative.
reformative, okay.
Compensation.
Deterrent is not there. Death penalty, you are killing the person. That is the most deterrent. If you see all these except E, all the 5 theories are followed everywhere. So if I have to choose that in Indian situation, which theory is prominent, I cannot give you an answer. And that is why some of the scholars said that we in India follow multiple approach theory. हम ये 5 theory को follow करते हैं. Whenever crime is committed and a person is punished, we follow all the 5 theories. And that is what it is at the end. Right? Justice Krishna here made a very beautiful statement that if the potentials of prisoner person are unfolded, a robber may become Valmiki and a sinner may become a saint. So सिर्फ सजा देना काफी नहीं है. Reformation, making him to understand, expiate, all the 5 theories are equally, there in our system, and no single theory is followed in India. And I think that this is the last thing that I need to put up in a bird's eye view. But trust me, this is just the tip of the iceberg that I have shown you in criminal jurisprudence. Each one of these things you have to study in great detail to become the greatest lawyer of this country. Right? So to be continued, why? Because tomorrow when I meet up, I will bring certain, I will touch upon certain things in Indian Penal Code and not teach you Indian Penal Code, right? So that is all for the day.
Thank you so much. Ma'am.
Thank you.
Thank you to all of you.
Thank you, ma'am.
Chalo, bye. Thank you for patient listening. So, ma'am, I think you can wind up.
Yes, ma'am.
I will also stop sharing.
End the call.
Yeah, please end it because I can leave it. Chalo, thank you so